program is IP training and education in changing IPR domain, right? So this is really very good topic, and this is really a need of time in today's rapidly changing world economic scenario. Today is the time of, we can say, intellectual economy. The information, knowledge is the power of world economy. The country which are more intellectual, the country which are more innovative, they are regarded as the world leader. And of certain parameters based on which their innovativeness is calculated, one of the important aspect is intellectual property. Intellectual property, right? And that is how which countries are creating what amount of intellectual property. Based on that, they place or they secures a quite good position in the world economic and the business scenario as well. So during this presentation, I will brief you about different types of IPR, why it is required, what is the world scenario in terms of different IP, what is India's position, right? Why, what is India's position and how we are lacking behind or how we can improve. And one of the biggest important reason, right? One of the biggest important area which is required to be focused or attended is the IP training, IP awareness. Right, in the later side, you will come to know what is India's stand and why it is important. So this would be the basic coverage for my session during this one hour talk. So friends, this is the second day and all of you are aware about the intellectual property right. Intellectual property right. So this is fundamentally deals with the intangible assets. Intangible means these are the items which doesn't have any physical form in the nature. Physical form. We know that this is a house, this is a furniture, this is your car. And for that, how you will prove your ownership, that is based on the bills and the registration paper. And you will say that, yes, this car is mine, this house is mine. I am the owner for this land property. Those are the tangible property. But this field of intellectual property right, this is fundamentally deals with the intangible properties or intangible assets. And the difference between tangible and intangible is their physical form. Intangible assets have no physical form in the nature. And fundamentally with respect to principles of the physics, the items which doesn't have a physical form, we are not able to see them. So again, new challenge is that the items which you are not able to see, how you will prove that you are the owner for those items. The item which doesn't, you are not able to see, how you will prove that this belongs to me, I am its owner. So intellectual property right, this is the area which deals with taking ownership on those intangible assets. And this fundamentally includes all the kind of human mind creations. Whatever is coming out from your brain, right? What is going on in your brain, the other person is not able to see what you are thinking or what is going on in your mind. With your intellectual, whether you create a solution of any technical problem, whether you write a computer program, whether you write a novel, whether you make a logo of new product, whether you make a new architecture of a building, whether you design a new product, new furniture, new jewelry item, okay, new cartoon characteristic, singing a song, right? Dancing, new dancing steps, writing a script of a new movie. So any kind of human mind creativity, scientific, technical, or a literary or a artistic, all those, whichever is generated from your brain, every kind of those items is capable enough to get it protected, right, and get it registered so that you can say that I am the creator of this item and I am official owner of this item, so that others cannot copy. Okay, so intellectual property right, this is the area which deals with taking ownership on any kind of human mind creativity, scientific, technical, artistic, literary, or any kind. In terms of medical science, we had seen that one kid might not have a one hand or might not have a one leg, one eye. But in terms of medical science, there is no possibility that no living human being exists without a brain. So every human being has a brain, and with that brain, every person has a capability to think differently, to create something, right? And the presently, because of the lack of IP awareness, we are not aware that whatever we have created, it has a potential to get it protected by means of suitable IPR instruments. So that is the domain of intellectual property right. So as I said earlier, what is intellectual property? So it protects and it covers all the kind of human mind creations, scientific, technical, literary, artistic, anything. So it is not only like that, it is only for the science field. No, it is also associated and equally associated with the artistic work as well, literature as well. So no person can say that I am the person who has a no role with respect to IP, or IP is not affecting my life in any of the way. IP is closely associated with each person's life, whether that is just a newborn baby or whether that is a very old age person who is just about to die. Whether that is for the rocket science field or whether that is just for the agriculture or food processing as well. So you might have, this topic is already covered, that there are different types of IPR, intellectual property right. It is a superset, right? And these are all different types of IPR: patent, trademark, copyright, design, integrated circuit design, geographical indication, and trade secret. So these are all types of IPR. IPR is a superset and these are the subset. And all these IP has a special purpose to protect special kind of human mind creativity. We will see in the example that what kind of creativity can be protected by which of these instruments. Okay, so these are all different types and each has a special purpose. Now look friend, this is one important slide which covers many fundamental items of all different IPs. Okay, so these are different type of IPR. Let's say for a patent. So to get a patent, what should be the criteria of the human mind creation? It should be novel, non-obvious and useful. Okay, and these are the common criteria with respect to any scientific invention, whether that is with respect to mechanical, medical science, pharmaceuticals, food processing, agriculture, chemistry, anything. These are the common fundamental criteria for any field of invention. And if you're either a rocket science kind of very big and new invention or a just very small incremental invention, if that part satisfies this criteria, so very big invention or even a very small invention, they are capable enough to get it patented. Right? And if you apply for a patent, you can have a patent protection for a period of 20 years. And this requires, once you have a patent, this requires to be renewed every year basis. In India, they are governed by the Patent Act and the rules. Next is a trademark. So to get a trademark, what should be the criteria? It should be for a distinguished goods and the services. Goods and services. It protects, it has a protection of lifetime. Till the time if you keep it renewed, it will remain with you for 10 years, 20 years, 50 years, 100 years, 200 years, or even more, right? So it has a lifetime validity and it requires renewal on every 10-year basis. It is governed by the Trademark Act and the rules. Next is the design. So any item to be protected as a design, it should have a criteria of novel, ornamental or aesthetic appearance. Just the external look of the article. It has a protection of 15 years, initially for 10 years, further extended for 5 more years. It is governed by Design Act and the rules. Copyright. So copyright protects the original and creative work. Original and creative work. And this is really very broad area. We are also going to discuss about each of them in this next slide as well. Original copyright is for original and creative ideas. It has a validity of entire life of the creator plus 60 years after his death. So very long time period protection for copyright as well. And it requires a no renewal. It is governed by the Copyright Act and the rules. Next is the geographical indication. This protects distinguished product from the special geographical region due to which it has a special characteristic which the similar product from other regions are not offering. This is also offering the lifetime protection and it also requires to be renewed on every 10-year basis. This is required to be protected and this is governed by the Geographical Indication Act and the rules. So look, whether there are certain common fundamentals and characteristics of all the type of IPR, whether patent, trademark, copyright, designs, all has a certain common characteristics. So what are they? First of all, they are to be given for the intangible asset. Intangible. So first of all, you observe some problem, then certain idea comes to your mind, right? Whether I do like this, then it can be solved. So when you transmit your idea into a physical product, right, then the problem is converted into a solution. So that is the physical form of the product. But the original thoughts to create that is your intellectuality. So that fundamentally is the intangible, right? They are also transferable like your physical asset. How you transfer the ownership of your land or building or automobile car from yourself to other. In the similar way, these intangible assets can also be transferred like a licensable or selling out. Okay, so they are transferable. They are territorial in the nature. In whichever the country you apply, they will be valid for that country only. Here the territory means a country. So if you create something, a new technical solution of a very big industrial or a social problem, in your laboratory you have created R&D and find out really good solution. Suppose you go for its patenting and you apply for its patent only in India, right? Only in India, then it means that you have an exclusive right for a patent protection for that idea only for the Indian territory only. If you want exclusivity or ownership for the same idea into multiple countries, you require to go and have IP protection in those countries as well. So they are territorial in the nature. The country where you apply, they would be valid for that country only. Government gives, IP right gives you the exclusivity only to you. Only to you and no other, excluding all others. So government gives you this exclusivity on this is a legal maxim, quid pro quo, which means that something for something. So government gives this exclusivity in exchange of a full disclosure of the same. There are standard limitations and exceptions for each of them. What cannot be patented, what cannot be trademarked, what cannot be design protected, and all like all others. So government has defined a standard limitations and exceptions in the respective act itself. So you have to judge and evaluate whether whatever you create, whether that is not falling within these defined standard limitations and exceptions. All these are the time bound rights. Okay. Unlike physical property, whether it is passing to you from generations, all these IP rights would be time-based protection. So till the time, whether that is validity and if you keep it renewed, it would be your ownership. Once it is expired, it will become a public property and any other person is free to use them. And all these leads to give you the exclusive right only to you and excluding others, and which gives you a competitive advantage into the market, or which is useful to create some sort of your monopoly in the business, and which would be quite essential to increase your profitability, to increase or to secure your market position. So these are certain fundamental characteristic of all the kind of IP rights, whether that is a patent, trademark, copyright, and designs. So friends, look, these are fundamentally for the intangible asset, which has a no physical form, right? So to have ownership, you require to go through the defined procedures. You require to submit all the detailed required information. You require to pay the fees. You require to fill certain forms. You require to overcome the objections, right? That is given by the respective patent office. And at the end, when you satisfy all the things, the government give you certificate like this, the government certificate with a national emblem, or trademark certificate like this, light pink color, patent certificate like this, very light blue color, design certificate like this, or green color, copyright certificate white color, and geographical indication certificate. So based on this certificate, you can say that, yes, I am the owner for this invention. And this certificate gives you the exclusivity in the market. So that any other person, whether he is copying your trademark or copying your invention or copying a design. So based on that, you are the owner. And based on that, if any other person is copying, you are eligible to take a legal actions against them. Okay. So if whatever we are intellectual enough, we are creating many things, but if we are not going through the defined procedure, if we are not going through the defined forms, fees payment, overcoming the objection, and if you do not have this certificate, then you cannot say that this item belongs to me, right? And in those scenarios, if originally you are the creator and if any other person has copied it, if you do not have this certificate, you cannot take legal actions against others. So to have the intellectual ownership on any of your intellectual creativities, you require to go through the defined procedure, requirements, objection overcoming, fee payment, and at the end you will receive certificate like this. Friends, IP is associated with everyone's life. No person can say that IP has no role in my life. Whether that is, as I said earlier, whether that is just newborn baby or a very old age person, whether he is a scientist or whether he is an illiterate person, whether he is a prime minister or president of a country, or whether that is a normal civilian. IP is playing an important role in everyone's life, right? And how? So look at, these are the certain examples which will say that these are affecting, which are using these goods, and that's how they are associated with our life. Okay, so look friend, this is without reading any text. If I will say that what company's shoes is this, you will say that This is from the Reebok. And how you have identified? So that is based on this logo, this design. This is the identification mark of the Reebok company, right? So when I will say a Puma, what is their logo? What is the logo of Nike? What is the logo of Adidas? So these are the trademarks, brand name, right? Trademark. And this is a company, they made it so flexible that you will, in whichever the way you twist it, it will regain to its original position without any damage to product quality. So this category of product, they have marketing like a real flex. So Reebok is also one trademark. Real flex is also a trademark. What is the material they are using to make it so flexible? How they are manufacturing, that is their trade secret. What is the external appearance? So Reebok company itself manufactures 1,000 types of designs. So each design, external look of each product, they protect by a design. Copyright. So how they are packaging this product, what is written into that packaging, what is the color combination, what are their TV commercials, what are their newspaper advertisement. All those contents are the copyright protection. And what is the material, how it is so flexible, what is the process of its manufacturing. All those creations can be protected by patent. So similarly, with respect to any goods, whether that is your ball pen, whether that is a pencil, whether that is your water bottle, whether that is LED light, whether that is your chair, or even a very hi-fi scientific technical inventions. With respect to each item, right? Each item is subjected to multiple IPR protection by means of patent, trademark, copyright designs, and multiple others. So IP is useful for all the stakeholders of society, whether they are researchers to know what is done and by what way they did, whether and what new approach you can come up with. Academia to define how the industry is going on, what would be the new horizons to carry out the research and R&D. To know the industry, what would be the new inventions coming up in this field and how you can improve your product. What would be the new product from XYZ company for the society. So whatever is the new R&D is coming, whatever the new product is coming, those would be useful to the society and also to the government, right? So government, a world is facing the challenge of the environmental issues. So every country is nowadays talking about the carbon free business, carbon free product, carbon free industries. So for that, they require to come up with the innovative product. And to promote that, government is making the new policies or relaxation for the R&D investment, relaxation for the capital investment for those technology based products, right? So based on that as well, the government to make their policy for the electrical vehicles, for the renewable energy, for the waste management, or for the startup promotion into the food processing or export promotion or the IT industry or the aviation industry, wherever government wish to promote their businesses, they also analyze the IP trend and they make their policy as well. So that's how it is useful to all the stakeholders of the society. And importantly, it is applicable to all the technical domains in all the industry types. It is not like that it is only for the mechanicals or the electricals or the medical science, pharmaceuticals. No, it is applicable to all the industries, whether that is civil construction or agriculture or waste management or everywhere. And that's why we can say that IP is useful for all the stakeholders of the society. Now, look at this importance of IP for the economy. So there was one research study carried out in the European Union to understand that what is exactly the IP is playing a role into their economy. And the results are very encouraging. Look that, and this European Union, it means that there are nearly 25 to 30 countries into European Union. And this is a joint study of all those countries, which says that 28% of all jobs in the Europe are directly related to IPR based industry, which accounts for nearly 60 million, 6 crores. 38% of all employment in Europe are directly and indirectly related to IP, which is nearly 8 crore 20 lakh. IP-based industry pays significantly higher salary than the non-IP based industries. 42% of total economic activity of Europe is based on the IP-based industry, which accounts for 5.7 trillion euro, 42% of the GDP, very huge amount, right? So these all numbers says that how important IP is for one country. In India, we doesn't have any such study carried out, but this is also the important and equally applicable for India as well. Look at 28% of job of look at. So what are the IP based industry? Automobile industry, IT industry, pharmaceuticals, food processing, chemical industries. So these are all the IP based industry, right? And these all industries are also employing a good number of people in India as well, right? We know that the what is software engineer is earning is more than the worker on the civil construction site. So that IP based industries are paying more salary than the non-IP based industry. And we know that what is the contribution of IT industry in GDP, what is contribution of automobile industry, pharmaceutical industry. So these are also in India as well. These industries are also playing a significant role for our country's GDP. And that's why IP is really important, not only for R&D or the ownership purpose, it is greatly important for country's economy as well. Look, this is one example to showcase the importance of IPR for one company, right? This is one case study of the Apple company. So Apple is the richest private sector company in the world. Richest private sector company in the world, whose valuation is $2 trillion. Now understand what is that 2 trillion is equal to how much? 1 trillion is equal to 1,000 billions. So 2 trillion is equal to $2,000 billion. Now 1 billion is equal to 100 crore. So again multiply by 2000 into 100, that would be 2 lakh crore dollars. Now again converting dollar into rupee, multiply 2 lakh into 70. So that would be nearly 140 crore. 140 crore Indian rupees. 1 rupee is equal to 1 crore, like that 140 lakh crore rupee. 140 lakh crore rupee, that is the valuation of Apple company. $2 trillion. And we heard that many a times that our Prime Minister is saying that we want to make India a $5 trillion economy by 2025. A country of 125 billion people, 1.25 billion people, having so many big companies like Reliance, Adani, Tata, right, Wipro, Infosys, TCS, and many more. We have so many MSMEs, and still we, a country like this, we are planning to be a $5 trillion economy, and this is just a one company of USA whose valuation is $2 trillion, right? And the factor Look, friend, why it is important that the Apple is achieved this position, and for that, the important role to achieve this position is because of the IPR. Look at here. When the iPhone 7 was launched, today is the iPhone 12, right? But here is the case study, some figures with respect to iPhone 7. When it was launched, at the retail price was $650, whereas its original manufacturing cost was nearly $220 only. So they are earning nearly 250% of profit for each unit selling. And even though when via these figures are very publicly known, and even though when the new product launches in the developed country as well, people makes a line be outside their outlets. Why? Because of the company image, brand image, the Apple. That is the value of their company or trademark, right? So people know that the company has made a so great reputation that people know that this is a product from Apple. It would be the best in the quality with the latest of the features. Okay. So even though look, the company's valuation is so rich, the richest company of the world. But even the interesting fact about Apple company is like that, even being the richest company in the world on the present day, the Apple has a no single manufacturing plant of its own ownership in entire world. Not in USA, not in China, not in India, nowhere in the world. Right? And still they are having a so great valuation. They just focus on the developing the latest technology, making the best design products, protecting their IP in the best way around the world, and selling them with a huge margin. That is because of their IP in all the way, trademark, patent, design, and that makes this company so richest. So look at the different examples. There are a number of examples like a Google. So Google is also a similar product, right? A two PhD students project from the Stanford University. They just started with a one computer program logic. They developed one computer algorithm so that the person searches on the internet, and they deal those input keywords in a such a way via different validations, filters, and characteristics so that the base result comes on the top. So fundamentally, with that brain, with certain conditions and validations, they created one computer program, and within a period of 30 years, now Google has also become world's most prestigious brand of the world. Right? So that's why that is the importance of IP in today's time frame. There are n number of examples like similarly the Apple, Google, Facebook, WhatsApp, and many more. Right? Look at all these are based on different IPs. So this is the importance of IP in today's time. So we have to understand its importance. So there are, look is IP system in India. So this is look how the IP is governed into India. So as I said earlier, the fundamentally IP is governed by the government of India, government itself. This is not going to be granted by one agent or one college or one university. These rights are originally granted by the government itself. So how it is established into India? Government of India, Ministry of Commerce and Industry, then Department of Industrial Policy and Promotion. Okay. And under that department, we have a patent office, the Office of Controller General of Patent, Design and Trademark, and they governs all these different type of IP, patent. So these protects the innovative product and processes, technical inventions. Design protects the external look of the item. Trademark protects the unique sign of a business and the trade name. Geographical indication, this protects the products from the special geographical conditions. The copyright protects the expression of thoughts, the very wide field. This covers the novels, the song, singing a song, making a painting, making a new architecture of the product, computer program, all the cartoon characteristics, movies, all those copyright. Semiconductor integrated circuit layout designs. So any kind of inventions related to the chips, circuitry designs, all those can be protected by semiconductor integrated designs. So this is how the IP is governed into India. Look, this is how the office structure of India's IPR system. So we have IIT for engineering education. Likewise, we have one National Institute of Intellectual Property Management that is at Nagpur. For entire India, we have 4 patent offices into 4 metro cities: Kolkata, Delhi, Chennai, and Mumbai. One design office for entire country, that is at Kolkata. We have 5 trademark offices into 4 metro city and also one into Ahmedabad. One geographical indication registry at the Chennai. One semiconductor integrated circuit layout design registry at the Delhi. And one copyright office for entire country into the Delhi. Now, look friends, now we will discuss about the importance of IP in the education and the country economy. Okay, so the Global Innovation Index, this is the index which is making a ranking of the country based on the innovation performance. Right, and when we have to compare on the global platform, we usually compare India with the China. And look over here. This represents the comparison of India and the China on the Global Innovation Index over a period of decade. So 2010 to 2020. So here you will observe that from 2010 to 16, 15, our position is continuously declining: 56, 62, 64, 66, 76, and 81. Right? Then from 2015 onwards, India has started improving. 81, 66, 60, 57, 52, and 48. So first time in the 2020, India has entered into the club of most 50 innovative countries of the world. And look at over a period of 15 to 20, right? India has jumped from the position of nearly 30 positions, 80 to 50. And this is also remarked, right? Very greatly applaud, right? On the world platform as well. In entire history of the world, no other country has shown significant improvements in just a period of 6 years. And this is closely related with the present national government. When the Modi government came into effect in the 2014, they started taking many innovative actions, right? They changed the different laws drastically, major changes into Patent Act, Trademark Act, and many acts. GST system, Atmanirbhar Bharat, Make in India, Digital India, Startup India, Innovative India, right? And many, many more initiatives. And because of all the importance, the ease of doing business, ease of promoting the startups, all this has improved significantly. And this has resulted into, these are the figures which speaks loudly about the how the India is progressing in today's time. Look friend, this is another scenario. This slide represents about the improving stand of India. This is the another slide which will also be an eye opener for us. This is the figure from World Intellectual Property Indicator. This is another international report which speaks about, look at patent, utility model, trademark, industrial design, plant varieties. This is 2017 and 18. This report says that what are the number of patents filed by entire world in the year of 1718 and who are the best performers. So look here, for the patent, the entire world has filed nearly 31,62,000 patents, all the countries of the world, which has grown to nearly 33,26,000 in 2018. Now, out of all these patents, the number one contributor is China. The world's filed nearly 33 lakh. Out of these, only China contributes 15 lakh patent. Nearly 46% of world is contributed by China alone. Look at number two is USA, nearly 6 lakh. There is a huge difference between number one and two as well. Utility model, again China is world leader with 96% contribution. Trademark, again China number one with 51% of the world. Industrial design, number one is China, 54%. Plant varieties, China, number one, China, 28%. So we know that IP is the power on today's time for the global economy. And China, they achieved this position, and on apart from this as well, on many fronts, China is growing very rapidly. And that's why it is a global challenge for many players to control China. Right? Many countries are boycotting, or China is not hearing or not making a deal with many countries on a fair terms. So that are different challenges, but friends, in terms of intellectual creation, on the present day, China is the world leader. And they didn't come on this position over a period of last 3 or 5 years. Look at this slide represents the top patent filing countries. China 15 lakh, India just 50,000 patent. Where is India's stand? And over here there are two colors, a red and orange. Red is by filing by the national citizen itself, and orange is by the foreigners. So look at China, whatever they are filing, of total filing, just 10% is by the foreigners. Look at India's position, our patent filing itself is very small, and of that, look at India's contribution is very minimal, whereas foreigners' contribution is nearly 70%. 70%. So India's contribution is very, very, very minimal. Indians, we are a country of 1.25 billion people. We have so many MSME units. We have so many big corporations. We have so many government institutions or academic institutions, and so much beyond that. We are the youthest country in the world. We are the largest producer of engineers or any terms of technical manpower in the world. But still, beyond that, our IP creation is very minimalistic. And the biggest reason responsible for this is the lack of IP awareness. Lack of IP awareness. And as an academic player, we have to focus on that. On the present day, we understand that patent means it is for the PhD student. It is for the person who has access for all the resources. It is for the guys who has access for all the instrument or the research resources, research paper and all that. It is for the people who always stay within the books, right? But it is not like the same. Every person who observes anything around themselves, they think differently and they solve a problem. We are great in terms of any technical problem, but we doesn't know that whatever we are creating, it is also eligible to get it patented. So we have to focus towards more and more IP training, IP awareness. every kid for IP going for a patent, trademark, copyright protection, there is a no criteria like a minimum age or a minimum qualification. It doesn't require that minimum 18 years or minimum graduation. Even a 5-year-old kid or even a 80-year-old illiterate person, whoever thinks differently and originally creates something with their brain, every person is capable to go for patenting. Patent doesn't mean that it is for the rocket science, right? Every person, whoever is creating something different, can go for patenting. Okay, so look at this. How China has progressed over a period of time. This is representing, this slide represents the same. The China's growth over a period of, you can say, a 2 decade, right? So look, China is over here, India is over here, right? So China is on the scale of 0 to 80, whereas India is on the scale of 0 to 8. So do not consider this graph are equivalent, right? So when it is started in the 1995, China was on the position of 1. India was also on 1. China understand the importance of IPR. They started large-scale IP promotion, awareness, and supporting activity. They made a large-scale policies to promote the innovations. And as a result of this, right, they progressed in the next 10 years from 19 to 2005, they progressed from 1 to 10. And India progressed from 1 to 3, right? And they continuously started, right? Whatever they decided over here and started taking action over here, this has given a result into next decade. And they progress in next decade, they progress from 1 to nearly 70. And India progressed from 4 to 7. Right? So whatever the global position they achieved on the present day, it is not just like over a period of 3-5 years. They achieved this because of their strategic actions and planning over a period of 2 decades. So friends, if we want to focus on all these areas, we have to start actioning on the present day. If we will not do today, we are saying that we are the youthest country. If we will not inculcate the energy of our youth present day, we will make a big mistake. And when our population would be very elder, we would be completely dependent on other countries. Knowledge is the power, technology is the power, right? So these are the country who focuses on this. They would be creating, the future will be belongs to them, right? And as academic institutions, our job rules should be focused towards doing more and more kind of IP awareness, more and more doing R&D. Our students are doing a monotonous projects. Many a times it is a nationwide problem in terms of tier 2 and tier 3 colleges and university. We observe that whenever our students are doing a project, they usually take up the same project what their seniors have taken. They usually copycat the same. We have to encourage our students for doing the R&D. We have to encourage them to report the false results. In fact, whatever the attempt they have made, in fact, the results are not as per the expectation, is the results are the negative. We have to encourage the students to report the negative results as well. Our student has a mindset like that. If they are doing a taking a project and if the end of the project report is not the positive, they are not going to get the good marks. They are not going to clear the semesters. And that's why they are taking up or ending up the copycat projects or the duplicative work. So as an academic player, we have to encourage our student for doing the R&D projects. It is not like that. No institution, we do not have an infrastructure. That's why we cannot able to do a good R&D, right? with respect to whatever is the infrastructure access available to you, there are ample amount of problem in the industry and the society, which you can solve with respect to the resources what you have. There are a large number of problem of the ground level, middle level, and your top level. So with whatever the access you have, you can solve those level of problem. And when you solve it, do not consider like patent means a completely new generation of product and process. If you create even a small change into existing product and process, really very, very small change, that small change is also capable enough to get it patented. It doesn't require a completely brand new product or a process or like a rocket science. So we have to break all these misconception into our mind. We have to encourage our students towards many of the things, right? Many of our, there are many, this is due to time limit. I would conclude my presentation over here. There are many slides over here, but this is, look, I would say that in the present day, look, as an academic player, we are giving more importance for the research paper publication than going for a patent. Even any students or the faculty doing some good projects, because of lack of awareness, we are rushing behind publishing a research paper than going for a patent. So there are two scenarios. You develop something, you go for research paper or go for patent. What would be the difference? So look, research paper gives you no ownership, whereas patent will give you the ownership. In fact, while you go for research paper publication, while submitting the paper, the publisher will taking over your ownership. When you submit paper, you submit the copyright transfer certificate as well. Right? Whereas in case of patent, ownership will always remains with you. For research paper, there is a no novelty criteria, whereas for patent, novelty is the must. Right? And if you go for a research paper, and if any other person copies the same and doing a business, either of 1 crore, 10 crore, or 100 crore. But if you first disclose as a paper, then as you have a no ownership, you cannot stop them. Right? That is yours. That is morally yours. You are the first creator. That is all true, but you cannot stop them legally. Whereas if for the same invention, if you go for a patent, you can legally stop them because you are the owner for said invention. Right? So this gives you the legal ownership. So do not consider, do not give more importance to research paper and do not rush behind publishing them. Right? Just whether your invention is really good, and this is with respect to patent, but with respect to all other aspects as well. Try to understand your creativity and go for its authentic IP protection. Look, research paper to patent filing is not possible. First research paper and then patent is not possible. Whereas first filing a patent and then a research paper is always possible. So make a wise decision. If you have developed a good research project, so do not whether via what means you have to go, research paper or a patent. Right? And look at this India's patent filing. Look, I will, and this slide. Look, this is India's research publication trend over a period of 2011 and 18. So we know that India's patent filing just 50,000, and of that, Indians patent filing is just nearly 17,000 patent in a year. And look at China. In the same 1 year, 365 days, China files 15 lakh patent. 15 lakh patent. Whereas India is just filing 17,000, 17. Right? Whereas look at India's research paper publication. Scopus listed journal, SCI listed journal, NSF US listed journal. So look, in 2018 alone, Indian has published nearly 4 lakh plus research papers. So this represents that we are creating a lot many things. But our academic system, our mindset is like that. We create something, but our faculty and our entire academic system says that go for research paper publication, research paper publication. Many of these things are eligible for IP protection, right? But because of the lack of IP awareness, we are not going for instead of patent filing and rushing of all these research papers and these results to no ownership to your end. So as an academic player, I will just conclude my presentation over here with a just small message to all the faculty members, right? Try to evaluate whatever you create, whether that is eligible for IP protection, patenting, or any other means or not. Do not just blindly rush behind the research papers. And do not just like say that we do not have enough infrastructure, so we cannot go for patenting. With whatever the resources available to you, just look at around yourself. Industry and society has a lot many problems which you can solve with them. Focus those problems and motivate students to report the negative results as well. Right? And if during this journey, if they are coming up with really good solution, encourage those students with a smaller invention as well for a wise IP protection. So with this, I would just like to conclude my presentation over here. Many faculty has given many questions. We can, if the organizers permit, we can take few questions, or another speaker would be in the line to speak about the next session. Thank you all.
Well, thank you so much, Mr. Patel. It was really an informative and insightful for all of us, and it has been really a learning experience. Because if personally I say, I myself did not know many of the facts put forward by you. So I would definitely keep it in my mind, and of course all the faculties from various institutions might be jotting down the points. You have touched, I think, every point related to IPR, right from the criteria and validation, nature and fundamentals of IP rights. Also, you have clearly defined all the necessary steps to go through while filing and registering a patent, trademark, design, and copyright. You have defined how IP is entangled to everyone's life, irrespective of the power, position, and beautifully given an example of the Reebok shoes. So all that was very informative. You have also defined the usefulness of IP to researchers and academicians, and by stating the facts, you have made a detailed comparison how India is lacking behind the other countries and what are the steps to be taken to improve further. So I think you have definitely done justice to the topic, and we have really learned a lot. Now, moving ahead, I would like to take up the questions in the chat box. So I'll be reading it one by one. Okay. The first question is, what is the difference between trademark and copyright?
Okay. So look, trademark is for the goods and services, identity. Okay. Say for example, look at we can say that Nestle. Okay, Nestle is one company. So Nestle has a trademark for that company itself, but Nestle is selling noodles on the name of Maggie. So Maggie is also a trademark, and many other companies are also selling the noodles by a different name. But because Maggie is the registered trademark of a Nestle, Maggie, that brand itself has a greater value. Okay. Nestle is selling coffee on the Nescafe. Nescafe, and that brand is also a trademark. So suppose, let's say tomorrow Nestle decides that I do not want to come up in the business of coffee itself. They can start their business. But as they have a trademark ownership on the Nescafe, that name, any other businessman would be ready to take up that as a name ownership, right? So trademark gives the identity of the product, trade name, okay? Whereas copyright is with respect to expression of your thoughts. That is writing a book, writing a novel, music composition, writing a story, writing a software and all that. And so these are two aspects. Trademark is a trade identity. Copyright is the expression of thought. Here, I would also like to say about the intersection of these two. Trademark and copyright intersection in the business. So look, many a times the company, beyond their name as well, companies are also protecting their labeling as a trademark. So how the Parle-G wrapper, is coming, that wrapper is also a trademark of a company. And company has also taken a copyright for that wrapper, so that company will reproduce the same wrapper and no other can copy what is the color combination, what is written over there, right? And with that wrapper as well, other will recognize this is the Parle-G biscuit. I hope this make a clarity.
Right. Okay. So moving on to the next question, there's an interesting question over there. Is there something special I should know if I do business or sell goods outside India? Maybe related to IPR. Yeah.
So there are many things you should taken care. With respect to IP, I would answer this question that with respect to IP, if you are selling those goods into those other countries directly with your name, right? As a seller or as a brand name of your company. So first thing you have to check is whether the same name is registered trademark of any other fellow is or not. Parle-G could be a trademark of Parle-G company in India, but it might be possible that if they have not protected this trademark into Europe, any other local person can apply Parle-G as a trademark into Europe, and that would be their trademark. Okay, so first you have to check whether that is as a brand, it is available here, and if it is not, if you are going to directly sell that, you should protect as your trademark. Another thing with respect to patent you should see is that freedom to operate or FTO analysis. If you will go and sell that product into that market, you have to evaluate with respect to any of the raw material or any of the process, how you produce your end product, whether with respect to any raw material, process or the end product. Via selling that product into that market, you are not going to violate any of the existing patent of any person. And this differs from country to country. So this freedom to operate analysis you have to carry out country to country base. It is not the one FTO what you carried out for Indian market. It has no relevance for the same product when you wish to go and want to sell that product into Germany or any other country. For that country, you have to carry out a different FTO. I hope that made a clarity to your question.
Yes, sir, definitely. Next question is composition of medicine or a vaccine needs to be patent or copyright?
Yes, it requires to be patented. Look, each product, it is not like that one product has one patent, right? So medicine and vaccine, for that medicine and vaccine as well, there are n number of applicable patents. One patent with respect to their culture development, one patent with respect to their extraction, one patent with respect to their purification, one patent with respect to that product preparation, patent with respect to their quality checking, patent with respect to medicines, right? So there are a different patent, and as I said earlier, right, medicine and vaccine. So they are also, there comes a patent, copyright and trademark, all are as well. Technical aspect as a patent. This Covishield or Covaxin, they are the brand name. They are subject to copyright, trademark protection, and whatever would be the packaging, right? Packaging of that product, color combination, what is leaflet available in that packaging, that is also subjected to copyright protection. So one product, one end product can be a bunch of hundreds of patent as well, right? And the simplified the example is, look at your phone. So this phone itself has a thousands of patent. The patent, these were hundred of patent from the Apple, from the IBM, camera patent from the Sony, the processor patent from the Intel, or multiple like it. So it is not like that one product, only one patent or one trademark.
Right. Okay, sir. Next question is similar. Can an article in a newspaper be protected?
Yes, it can be protected by means of a copyright. Whatever is content you are publishing in any of the modes, newspaper, magazine, blogs, or any other way, they can be protected by copyright. And look, copyright says that copyright is a automatic protection. The day when you create it, it becomes your copyright, even though you register it or not register. But if you go and register, that certificate would be the prima facie evidence that you are the owner who has applied for it and is the owner. Still, you do not go, it would remain with you only.
Right. Okay. So next question is, sir, so the right thing to do is first go for patent and then publish your research paper.
Yes, exactly. Very true. Very true.
Right. This is from the last slide you explained. Yes, this was my question too. Okay.
Okay.
Uh, yeah. Next, moving forward, if we apply for copyright in a research paper, then can that be legally protected?
Look, research paper, if you publish, if you first apply for a copyright ownership for the research paper, what you prepared, okay, that would be your copyright. But that would be remain with yourself. But getting it to be published in some reputed journal, you will require to submit it with them, that journal. And when you submit them, as a part of that process and submission, they requires, one of the requirement is that assigning copyright ownership to that publisher. So even though you are the first copyright ownership, to publish your research paper into that journal, you assigns your copyright ownership to them. So from that point onwards, the original copyright owner would be that publisher and not you.
Right. Okay. So next question is, how should ownership of a patent be determined?
That is based on the certificate. You go and apply for a patent, prosecute your application, pay the fee, overcome all the objections, and at the end, when you satisfy all the need, government will give you the patent certificate, right?
Okay.
And when that certificate comes to you, it is your ownership. And to check whether that patent is valid or not, it requires yearly renewal fee. Till the time, if you keep on paying the fee, that would remain the valid. If you will stop paying the renewal fee, that patent will cease to be in the effect. And patent will, from that point onward, that patent will not be legally valid, and it would be regarded as a public property.
Okay. So how long it takes to get a patent for the research paper in India?
Look, as I said earlier, research paper to patent, it is not possible. Government Patent Act says that within 1 year you can go for patenting, but even though you will go for it, the examination report itself, there are a good chances that examination report itself will put that your research paper itself would be the one of the objection, right? And even the patent would be granted. If it is making a huge business, then you will face a legal challenges as well. So I would always recommend, look, whenever you are going to go for research paper publication, all the details are ready. All the details about the projects are ready, right? And with the same detail, with a little modification, you can go for the patenting. So for patent and research paper, it doesn't require two different items or two different goods, right? You just required how you are basically the same man who wears a different clothes, right, on different days. In the similar way, patent and research paper both has the same technical requirement. Just some little or more amendment, and you can first go for the patent.
Okay. So next question is, art on digital platform, can it be patented too? If you have time, would like to know.
Art, as I said earlier, art, whatever, look, whatever the painting you made, whatever the new design of architecture you give, right, or whatever, those art would be the subject of copyright protection, whether on the digital platform or whether in the book format or any other way. Okay, even the whatever the picture you take into your mobile phone, that is also subject to copyright ownership.
Okay.
You accidentally captured one video and that video goes viral, right? So in that scenario as well, you originally had taken that video and that copyright ownership belongs to yourself.
So next question is very interesting. If someone's patent is stolen by other and owner of the patent is not known about it, that his patent is being used, then how can be detected and by whom?
So yeah, this is interesting. And look, friends, so can be detected and by whom? So that job you have to perform, you have to do. Say, for example, I would answer this question in a different way. Like, say, for example, you are the owner for one land plot on the crossroad, right? Now, that is your land plot. You are the owner and you have a right whether to build a restaurant on it, whether to build a hotel, whether to build a shopping complex, or whether to build a supermarket complex. That is your property and you have a right to do whatever you wish to do it. Now, and suppose you are like that, I do not want to build anything now. I will do something after a period of 10 years. So to have a great market pricing advantages. Now, during this time period, if any other person take over to your property and he started his restaurant or something on that property, so who has to take action to stop that guy? You have to, right? You have to go to that person, you have to send a legal notice, or you have to file a police complaint against that person, right? And then the police system or the court judiciary will take actions against it. So in the similar way, right? For that scenario, it is not the job of policemen or court to see and keep watch on everywhere. Who is belongs to whom and who is doing the mischief, right? And then court or policemen are not taking actions against them. We have to initiate the action. In the similar way, patent is your property, and if any other person is doing a mischief or taking a wrong advantage of the same, it is the you, right, who have to identify that guy, and it is the one who have to initiate legal actions against that fellow.
Okay. Okay. So I think the comment section is full of thanksgiving for your presentation and answering their doubts. Lastly, I have one question that as we saw in today's presentation, your PPT is copyright. So can we access it from any other place or can we use it?
Yeah, definitely. Look, I will definitely share a copy of the same with you, which you can
Okay,
forward with all the participants as well, but with a due credit that uh,
of
uh,
course.
you have received a copy from myself, right?
Right, right.
And as I said
Okay,
earlier, copyright is the one, this I have written over here. It doesn't mean that I have applied and taken copyright. While this presentation, if you had taken any note into your notepad, that is also your copyright, right? So the day when you created it, it becomes copyright is an automatic protection. Okay.
right. Okay. I'm sure all the participants are unquestionably satisfied with all your answers. And
Thank you.
so I would like to thank you so much for your presence. And definitely your presence has added an extra feather to this FDP. So thank you so much, sir. Yeah.
Yes, it
Now,
would be my pleasure to be with all of you and to interact with all of you too. But I would also I would I'm little bit sorry as well with respect to advocate uh, Misra, right? I had taken some of her presentations time, right? Uh,
no,
yeah,
sir,
thank you.
that's really okay. Yeah. Okay, so I am requesting all the participants to kindly fill up the feedback form and solve the assessment uploaded in the Moodle platform. Next session will be taken up by Dr. S.P. Roy, Professor of Law, Dean Research and Development, requesting all the participants to join sharply at 2 p.m. for the session. So for now, I, Vanita Karmakar, signing off for this session. See you all in the next session. Yeah. Thank you all. Thank you, sir. Thanks to all.